May I please, Your Lordship? Your Lordship, I beg to mention item number 9 of today's daily list, Your Lordship.
9.
9, Your Lordship.
9 is which 8.
8, Your
perhaps.
Lordship. Yes, Your Lordship, actually, my senior F. Begum, she's really not well, Your Lordship. My senior Mrs. F. Begum, Your Lordship, she's not well, Your Lordship. So
Have you informed the appellant, counsel for the appellant in item 8?
Yes, Your Lordship. I have informed, but they told that they will do the matter, but they don't have any objection if we do our matter later on some other day.
Then let us, you be there.
Okay, Your Lordship. Oblige. May I please, Your Lordship? I beg to mention item number 10. I have taken consent from the other side also, Lordship. Mr. S. Bhotago is secretary and my Lordship.
Mr. D. Gogoi.
Lordship.
Okay. Mr. D. Gogoi, learned counsel appearing for the appellant, has sought for listing of the case after
2 weeks, Lordship.
2 weeks. It is submitted by him that consent has been taken from the learned counsel for the other sides to make the prayer.
Lordship.
So the prayer so made, comma, is allowed. Is the case after 2 weeks on the date to be fixed by the office.
Highly obliged.
Daily list for admission. Item number 1.
Yes, it is Lordship. Appeal against conviction of POSCO.
415 to Bharatiya Nagorik,
There are 5 appeals.
against the judgment and order dated 26/6/2024. Session Judge Tinchukia. Sessions case number 24 within bracket CH of 2018. (302). Rigorous imprisonment for life and to pay fine rupees 5,000 in default of payment of fine, to undergo rigorous imprisonment for another 2 months. We have perused the memorandum of appeal, the criminal appeal, case records, issue notice, returnable in 4 weeks. And Mr. Das appeared accepted. This, the learned counsel for the accused appellant shall take steps for service of notice upon the respondent number 2 by registered post with AD within 3 working days. This is the case after 4 weeks.
I may be heard after receipt to LCM.
Same, not 318 in 430 within bracket 1. Bharatiya Nagorik Suraksha Honita 2023. These people seeking suspension of the execution of sentence. By individual person, issue notice returnable in 4 weeks. The steps opposite party registered post with AD. The learned additional public prosecutor shall make an endeavor to file objection to the instant application or not before the returnable date.
But 302 in the IAV you also have to take steps. Man.
In
the IAV you have to take steps as well. Man.
Or steps, yes.
In
Take
the IAV.
steps. Whatever.
Obliged, man.
Item number Item number 4.
Meet please, Lordship. Okay, 302, neither AD card nor answer notice returned, but the LCR is.
Put it before Lojima court, put a report. Heard Miss B. Sharma, learned legal aid counsel for the appellant, and MS B. Bhuyan, learned senior counsel and additional public prosecutor, assisted by MS R. Das, learned appearing, learned counsel for the respondent state. First up. As per Office Note dated 6/2/2023, notice issued to the notice was issued to the respondent number 2 by registered post AD on 6/2/2023. First stop. Continue with Tati. As per Office Note dated 29/7/2024, neither AD card nor unserved notice has been received back after service from the respondent number 2. First stop. Let the case be placed before the Lajima Court to submit a report as regards service of notice upon the respondent number 2 after tracking the registered article from India Post. List the case after 2 weeks for report.
Item 5,
Yes.
Lordship, in this
Yeah.
case, I was supposed to give an extra copy, Lordship. But the written objection was filed by learned senior APP, Lordship, as Zahan. So grant me 1 week time, Lordship, so that I can communicate and give it to.
Next week then. Next week.
They filed the, what they are saying, they filed the objection. That is not traceable. That is what he is saying now. So,
So you are not Mr. Chaudhary as
I am for item number
received the
8
objection to
items
the
are there.
interlocutory application.
out of same guy.
MS Jahan as filed
Right.
and a copy was supposed to be served to Mr. Ahmed perhaps no?
Yeah.
On the previous day. That was the order. Now you say that you don't have the copy itself.
Lordship, I will provide by asking Lordship as Zahan. She is looking into it. Lordship.
You get the copy?
We'll have a copy from office if your lordship parliament matters. It will save time, Mike. Your lordship, short days.
Mr. Isha Chaudhary. Right. Learned Senior Counsel. Assisted by Mr. A. Ahmed, Learned Counsel for the appellant, and Mr. K.K. Das, Learned Additional Public Prosecutor for the respondent number 1 state. Post up. Mr. Das, Learned Additional Public Prosecutor, has submitted that the objection filed to the instant interlocutory application. The copy of the objection filed to the instant interlocutory application has been misplaced in the office of the public prosecutor, Guwahati High Court. Post up. He has thus requested to furnish open photocopy. To provide him a. Do you have the copy?
I don't have, but.
Huh? Oh, objection you have not received.
We'll make,
You have not received.
that is not, we also do not find it.
Okay. To provide a copy of the said objection from the office, post of para. Office to furnish a copy of the objection filed by the state to the instant interlocutory application. Yate asen nai. To asen nai. Yate asen nai. Copy asen nai. Okay. It I did you. Order to I pass koribo. Within 3 days from today, release the case in the next week. Next week. Next week, not 1 week. Next week.
Next Tuesday, can be fixed, man.
No, not Tuesday. Tuesday, the IA will not be listed in Tuesdays.
Wednesday?
Next week, today is Wednesday.
That
Okay, next week. Next week, did you?
month is what? 7. 7, 8. Obliged to.
item 11,
Matrix.
Offense MH law score
I think
30.
LCR has been received,
Hmm,
but as per
it will
office
be-
dated 26/7/24.
address. Those were you here. Those were you. Hmm? Nothing. I got 302. 302.
302.
And Mr. M.H. Loskar, learned amicus query for the appellant, and Mr. K.K. Das, learned additional public prosecutor for the respondent number 1, State of Assam, full stop. Notice sent to the respondent number 2. By register post, which AD has returned back with remark, comma, no such address in this address. A official person. Hence return to sender first one. Para. Mr. Das, additional public prosecutor, has submitted that since the interest of the respondent number 2 would also be represented by him, comma, the appeal can be heard dispensing with the requirement of dispensing with the representation of the respondent number 2 as the offense involved is section offense involved in this appeal is under section 302 IPC. So as the I could end this now, I don't know. Where this as the as the records of the trial court have been received, comma, office to make out an endeavor to trace out any and trace out alternative address of the respondent number 2, if any. If any alternative address of the respondent number 2 is found, comma, steps should be taken in such address. Full stop. Now, as the records of the trial court have been received, comma, office to prepare the paperwork in the meantime. This is the case after 4 weeks of life.
This case, LCR was called for, but that is not received.
LCR not received.
Not received.
What? Reminder issue question. Huh? Reminder 15/7. Okay. The reminder is why not admitted appeal? Or Mr. Ahmed, learning counsel for the appellant, MSB Bhuiya. Respondent number 1, State of Assam, and Mr. A. Thakuria, learning counsel for the respondent number 2. Appeal correct. Let's let the criminal appeal be admitted for hearing. In view of the reminder issued on 15/7/2024 for records from the trial court comma, list the case after. Oh, no, not good. Wait for the records of the trial court, list the case after 2 weeks. Admit hola silo.
Item 14.
Admit.
May I please your lordship? This appeal has
Correct,
already been
correct,
admitted
yes.
on 15 May 2024, my lord. And LCR called, LCR received, and private respondent's name is also showing, my lord. Appeared his service is complete, my lord. So matter is ready for consideration.
We-
of I.
Yeah. Consideration of I.
Yes, my lord.
Did they file anything? Objection filed?
Yes, filed, already filed.
Okay.
By the-
How many?
Says she'll file objection.
Oh. How many witnesses?
Altogether, my lord. Here,
Let the paper will be also ready. PK Decca, learned counsel for the appellant.
total 12 witnesses.
Appellants. MS B. Bhuiyan. Learned additional senior counsel and additional public prosecutor for the respondent number 1, state of Assam. And MS
I wrong me.
R. Rongmei. Learned counsel for the respondent number 2. So, as the case records from the trial court have been received, office to take steps for preparation of the paper book, release the case after 3 weeks. In the appeal. In the PK Decca, learned counsel for the applicant's appellants. B. Bhuiyan, learned senior counsel and additional public prosecutor for the opposite party number 1, state of Assam, and R. Rongmei, learned counsel for the opposite party number 2. To stop. An objection to the instant application has been filed on behalf of the state. Full stop. Has already been filed. MS Rongmei, learned counsel appearing for the opposite party number 2, has prayed for and is granted. Same time, 3
Hello.
weeks to file an objection to the instant application. Release the case, 3 weeks, do it applicable.
Obliged.
Item number 15.
113 days in preferring the appeal.
Yes, Mr. Das, offense?
Section 6 of POCSO.
Yes,
Lordship, 1st August 2022. And if hearing does not take place, I will place this IA, Lordship. in the
okay.
meantime.
Paperwork ready or what?
Paper book is ready, Lordship.
A. Ahmed. Learned counsel for the appellant. We keep it pending, we'll ask the AC to fix this case for hearing.
Yeah.
If you want, you will make a mention for I,
Lordship.
will not dispose it of.
Lordship. In the meantime, if they want, they can file their objection also.
Then we have to pass that order.
That objection you will.
And Mr. A. Ahmed, learned counsel for the applicant appellant, and Mr. K.K. Das, learned additional public prosecutor for the opposite party state of Assam. Full stop. Mr. Das, learned additional public prosecutor, has sought for and is granted 2 weeks' time to file an objection to the instant interlocutory application. Full stop. Raise the case. After 2 weeks,
In main appeal that I have.
I will not pass any order on main appeal.
Main appeal
This
will
should be going in two directions. This should be going in two directions. Let this come. If you don't press, then we can go for hearing.
Obliged.
Supplementary list, item number 21.
Lordship, appeal against conviction, Lordship. The I is pending, Lordship. Kindly matter may be list after 2 weeks, Lordship.
2 weeks. Sunday Prabha. মানে এটা সাপ্লিমেন্টারি আছে নাকি? Wait. Okay, MS
B Goswami.
B Goswami, learned counsel appearing for the appellants has prayed for listing of the case after 2 weeks.
Yes.
Goes to Mr. K.K. Das, learned additional public prosecutor for the opposite party, state of Assam, is present. Goes to as prayed for. Release the case after 2 weeks.
Lordship, we have received paper book yesterday, Lordship. Obliged.
I had liquid. I had again. I.
Pending item number 5.
I would have given the judgment, my lord.
Let us see.
My lord, the first judgment is by the Honorable Karnataka High Court, my lord. 2003, Zero Supremes, within bracket Karnataka, 636. My lord, will kindly come to paragraph number 3 of the judgment.
Today, Lordship. Only for today, Lordship.
For today, you could
Only for
have
today.
circulated it.
Lordship, yesterday, because of those other cases, I could not go through it properly. Lordship. I can argue the case today, sir, but that will be unfair for him, Lordship. Only
Okay.
for today, Lordship. Tomorrow, Lordship.
But for next time,
Lordship.
tomorrow there are matters again. People are
Lordship.
waiting
Only
perhaps.
for that day, Lordship.
Okay. A. Ahmed, learned amicus. Jury for the appellant. And Mr. K.K. Das, learned additional public prosecutor. For the respondent state are present. Those two. On the prayer of Mr. S. Read for by Mr. Ahmed. Learned amicus curiae, lays the case on side you next week. You are in detention for
2 years.
2 years. During trial, you were on bail.
Yes, during trial on bail. Lordship.
Okay. কিবা fix আছে নি 8 তারিখ? No? 8.
Obliged. Sorry, Lordship. Obliged.
Item 20.
That's My senior MS Sharma, she is so on her way.
Hmm?
My senior MS Sharma, she is on her way.
He is?
On her way, she is coming to.
That's me. Are you? And this, no, I think one.
In this Nobin Gupta,
No, yes,
Nobin Gupta repetition.
ma'am.
What is the forest royalty? 29 lakh 40,259.
Yes,
And plus 73,506 towards income tax.
my lord.
Then there was a final bill.
There is a final bid that is pending.
And they are contemplating to deduct amounts towards forest royalty out of
Right.
that final bill.
Yes, ma'am. My prayer is that earlier they have deducted, that can be refunded and the further deduction may not be made. Pending.
In case of the other one,
In case of the other one, my lord,
Pranjal Gautam Paul, second running bill, 15 lakh
15 lakhs,
7,775
my lord,
and 37,694.
my lord.
Then 1 crore 6 lakh 65,250 pending.
Yes, sir. The calculation they have made in page 63, my lord, the earlier bill.
Whether this figure is correct or not, I'll not look into it if they say that. I have mentioned the amounts,
Yes.
whether this is correct or not.
That is reflected in page.
According to those documents, correct or not? I
Yes,
have all, huh?
Yes.
Both the petitioners applied for permits.
That in the second, in Pranjal Gautam case, I had annexed in the,
Tell me, both have applied for permits.
that in Navin Gupta's case, I had no information.
Huh?
In the first petition, WBC 6391. That is not there. In the second petition, 6421, they have applied. The document is still there.
Nobin Gupta not there.
Navin Gupta.
Permission seeking permission permit.
That application I have,
Huh?
that application I have not.
Then why both are similarly situated? Because on the previous day, we recorded your submission that both the petitioners applied for.
No, my lord, I have specifically stated that I have annexed that permission at page 77 in the second petition. They appear, reply file in the IA 3377.
Where in the schedule, in the work order, 10% royalty will be deducted? Hmm?
Page 25 in WBC 6421.
No, what do you say about this? Including payment of compensation for borrowing out art from private land or forest royalty, if any, complete as directed.
In which lordship is.
This compensation payment for compensation for borrowing art from private land,
Page 25.
page 25.
Or first really.
Or.
There is or, my lord.
Now, what will be your submission?
Now, in my cases, my lord, I have compensation in the affidavit I have stated, my lord, that compensation, whatever has been made to the landowner, my lord. Compensation part. There is or, my lord, or compensation or first relative.
No, he is not a party to the agreement, this contract agreement. Your landowner is not a party to this contract agreement.
No. To my instruction, in fact, they have deducted 30%. When you go by the rules, forest rules as my learned friend indicated, it is 15%. If it is assumed that it is applicable, madam, for clay and art, it is 15. But entire exercise was done under the Assam minor mineral rules. My lord. The agreement was made there under the rule says, my lord, before amendment, there is no.
Please don't make submission. I have asked this. Because on the previous date, we have dictated that your submission, but that submission is both the petitioners submitted application. Now you are saying that
A humble submission is that in the.
because I dictated it
Yes,
in,
ma'am. I've indicated that page 77 of the second petition. We
I
have
have to
annexed
correct
the-
myself and again. So what is your submission? I have forgotten then. What is your submission? Why forest royalty should not be deducted?
Yes, my lord.
So, there you go. So, forest regulation or Assam minor mineral concession rules.
Firstly, my lord, it is the settled law that condition that to be incorporated the agreement, my lord. First ground, my lord. And that is not there in the agreement executed by between the,
But if something is in law is laid down,
my lord,
if law is there, suppose that royalty is to be collected,
my lord.
then how to prevent it? Firstly, let us see the Assam forest regulation
My lord.
one by one.
First, last to see section 4 definition of forest production.
Hmm?
Definition of forest production.
Huh?
Definition of forest production.
Yes.
Chapter 1, page 7 in this book. Forest produce includes the following whether found in or brought from the forest or not. That is to say, whether it is found from forest or not, in either way. Now we'll say, we'll covered by the second part, B, 4B. The following when found in or
We have
brought from-
forgotten everything, Mr. Das, so we are trying to recapitulate.
4B, the following when found in or brought from a forest, that is to say, last leachability peat, surface soil, rock, and mineral, including limestone. And my humble submission is the art from a private patta land. That is not within the meaning of the forest produce as laid down in the Assam Forest Regulation. And the judgment, my lord, I have relied upon the Bihar. There has been, my lord, observed.
Some land and revenue regulation.
Brihatter Dispur Mati Track Malik Santa, it is reported in 2003 to GLT 446.
Everyone.
My learned friend on the other day pointed out that
Mr. Hazarika, I am looking at some other thing, I
My-
am not hearing it.
yes,
So you want to say that ordinary art
Collected from the.
does not come within a definition of forest produce
My lord,
or
Yes.
not?
yes, my lord. That is.
Collected from anywhere or collected from forest? What is your submission?
Collected from forest, if it is collected from forest, it will come under the definition of forest produce. my lord.
How?
Yes, madam. I'm reading again.
Which one?
Section 3, subsection 4, my lord, forest produce, I'm reading it again.
Forest produce.
Forest produce includes, the first part we are not covered, the B, the following when found in or brought from a forest, that is to say. Now, if it is considered surplus 4 millet peat surface soil, if it is brought from forest millet, that will come, then that will come under the definition of forest produce. my lord.
Mhm.
And thereafter, my lordship will, if it, that notification dated 1st of September 2009, my learned friend relying upon my lord, PS 53, my lord, regarding royalties, my lord. Page 57,
57 of what?
clause 4, price for minor forest produce.
57 of what?
That is the regulation. Page
Regulation.
57, my lord. He was referring,
50?
it starts from 55. Relevant pages 57, price for minor forest produce.
Hmm. Forest regulation?
Yes, ma'am.
Huh?
Yes, ma'am.
57
57.
section.
No, my lord, page. I'm referring to page. It starts from page 53, my lord.
Hmm.
He is referring that price for minor.
What is this notification?
Yes, my lord.
In exercise of
In
power.
exercise of power conferred under section so the Assam Forest Regulation and Amendment, the Governor of Assam is pleased to publish the following schedule of rate of forest royalty reviewable on all classes of forest produce in
What are these sections? 32,
32.
reserve forests in unsettled tracts. 32. 33, protection of
Protection of unsettled
unsettled
forest
forest
belonging to the government.
belonging to the government.
My lord.
34,
2.
2D.
Yes,
No person shall make use of any forest or use. Two D. Then 2D, then H. Yes,
H.
Here's this notification.
Yes, ma'am. Clause 4 of this notification is referring my lord, price for minor forest produce. my lord.
Read the content first.
My lord. The Governor of Assam is further pleased to revise the rate of royalty on sand and stone, gravel and singles, etc. payable by certain department of the state and central government. That is PWD Irrigation Flood Control, CPWD Defense Department, Railway Municipal Corporation, Town Committee, PHE Development Blocks, BRTE, and Assam Police Housing Corporation for the undertaking works within the state. We have that water resource department is not there.
This supersedes all previous government notification issued in this regards and comes into the force with immediate effect from the issue of this notification and shall remain valid until further order.
There, which one?
Now they have relied that clause 4 price for minor forest produce and clause 16 rates for sand, gravel and stone.
Hmm?
Page 62.
Is
62.
62.
Yes, ma'am. Heading is at page 57, price for minor forest produce.
Price for minor forest produce. Hmm,
Then page 62, my lord.
yes.
Clause D, they are referring clay and earth, rupees 15. Lordship will also see section 20 down below, clause 20, my lord. The general terms and condition governing the issue of permit of sand, stone, etc. for the department undertaking of the state and their central government are shown as below. So they are quoting that rate and the clause 4 of 20 says that the respective divisional forest officer shall issue the permit only in respect of the above information. Why I am referring this clause, in all these sections, it is referring to the forest produce. If it is forest produce, then all this will be applicable. Now, in my humble submission, the art collected from the
Mr. Das, how this art from Patra land can be forest produce?
Logic, there is notification that
Uh-huh.
land
No.
is being extracted from private patta land also.
No, Assam Forest Regulation 1891
Logic,
is a statute.
logic,
Definition of forest produce is provided in the statute.
logic,
A notification cannot go beyond the statute.
logic,
That
logic,
page 52 or 54,
logic.
right?
Logic.
So if it would say that surface soil includes ordinary art,
Logic.
then it will be only when it is extracted from forest
Logic.
definition. Otherwise, it is not forest produce.
Logic.
So for the Assam, don't mix up one by one. Let us don't jump to others.
Logic.
1891. Forest produce is defined. There is no amendment. Then how can this notification can include ordinary art collected from non-forest areas? Leave aside all decisions for the time being. Let us concentrate on the statute. Then we'll go into decisions. Don't bombard with decisions. First, let us see the foundation. Then you construct the structure. Right? We'll come back.
my lord.
for the-
Now referring to the notification of 2009, my lord.
Hmm.
Clause 16 of the notification I have mentioned, my lord, that regarding rates of royalty. Clause 20 of the notification is dealing with the permit, my lord. In my humble respect, my submission is that in all these cases, my lord, if it is the forest produce, the permit will be necessary. my lord.
Yes.
May I refer clause 20 of that notification,
Is there any definition of minor forest produce?
my lord.
Because clause 4 says
4.
minor forest produce.
Yes, my lord.
16 or what?
It is-
4,
it
4.
is 4, my lord. I'm
Uh,
forest produce is not defined. But
Is it forest produce?
forest
Yes.
produce?
Ordinary art from Patta land?
Yes.
How can?
Lordship, if your lordship takes on that petition 6421 of 2022 in
Yes.
page 25. The specific, in item number 1, lordship, against item number 1, artwork in embankment by truck carriage in locally available ordinary soil, excluding rocky soil, free from roots and vegetations and filling in uniform layers, not exceeding 22 centimeter thick, including cutting and cleaning light jungles and trees up to 50 centimeter grid, plowing and roughening or benching the seats, removing all debris, breaking all cloths up to 2.5 centimeter cube, dressing as per design section, including payment of compensation for borrowing art from private land or
Oh.
forest royalty, if any, completed as directed. They have to, lordship.
No.
That-
So
There's two
forest
parts.
royalty when leviable?
Yes.
Forest, what, is there any definition of forest royalty? Forest produce,
Yes, lordship.
it is sure.
Lordship.
That definition is 2(4). Subsection 4.
Three.
On primacy look
Lordship.
of section 2(4), definition of forest produce does not appear to include ordinary art from Patta land. That is what the confusion is for the court. Please remove that confusion. That is what we are
Because-
asking.
Because for extracting the art, there has to be some mining process is to be there. Otherwise, art cannot be extracted, lordship.
Oh, no, Mr.
Lordship.
2(4),
Three.
there are two parts.
Yes.
Forest produce, whether they were extracted from forest or non-forest areas.
Non-forest.
That is one part.
Ah.
Second part of the definition is that from forest areas.
From-
That includes surface soil,
Gotcha.
right? Surface soil
Right.
definition is not provided. But if we assume that ordinary earth is included within the definition of surface soil, then in that case, it will be forest produce. Meaning thereby, if it is not from forest areas, surface soil will not be forest produce.
Mine.
My simple understanding of the definition.
That has been in 2003 to GLT, the Brihattar Mati.
We'll come to that.
Yes,
We'll,
Only in respect of this point, it is clarified. Madam. It says that it is mining, minor mineral, it is yes, but it is not forest produce.
one more I am trying to find out.
1891, Assam Forest Regulation Lordship.
1891, right?
P4 forest produce.
Oh, good. Because I'm asking this question because Assam Land and Revenue Regulation, 1886. Rights over land, Section 4. Land exempted from the operation of this chapter. This chapter shall apply to all land except land included in any forest constituted a reserve forest under the law for the time being in force. So, whenever forest is there, it will be Assam Forest Regulation. Otherwise, for all patta lands, the rights over land is governed by Assam Land and Revenue Regulation 1886.
Right.
Right. You cannot exclude Assam Land and Revenue Regulation 1886. So, for other forest areas, this will not apply. But for other areas, Assam Land and Revenue Regulation apply, and rights over lands, it will apply. Now, there will be then another question whether we'll come to that mines and minerals.
Gotcha.
But so far as Assam Land and Revenue Regulation is concerned, it is the proprietor, landholder, settlement holder, all these rights are with the patta holder. Then there is another law, I think.
If the petitioner could have brought the land for his own purpose, not for government purpose, then it would not have covered this. Forest royalty will not be applicable. But when it is used for some government purpose,
Where from you are saying that?
Lordship,
I am asking that where is the source of power?
that is decided in one of the cases, Lordship, which I have already given supplied to your Lordship, that Airport Authority of India case.
I have not found any solid basis there.
Even land, I mean, art extracted.
What
private land.
prevails?
Lordship,
First, what will prevail? Constitution of India. Next, the laws of the parliament. Next, the laws of the state. Thereafter, all these decisions. So, coming down from top, Assam Forest Regulation. Then other one was mines and minerals. Mines and minerals are central legislation. Assam Forest Regulation and Assam Land and Revenue Regulation are pre-independent legislation.
Okay.
And that has been saved
Okay.
by the Constitution. As on date, they are prevailing. So on that basis, let us come down from that, then we'll go to the decisions. But you are not saying the source of power. Source of power is to be there.
Yes, sir.
Forest produce definition does not include ordinary art from patta lands. Patta lands are governed by Land and Revenue Regulation 1886. Forest regulation cannot travel beyond forest.
Okay.
Because the preamble is a regulation to amend the law relating to forest,
Well,
forest produce, and the duty leviable on timber in Assam. Preamble. Is it not?
Yes.
So please enlighten us on that aspect. That this is the source. From there, it has percolated down to this. Nobody has discussed Assam Land and Revenue Regulation.
in all these documents.
I have not found. Have you understood my point?
Yes.
Now, forest definition privacy does not include if the ordinary art from patta land. Then where from that royalty will come? We have to see the definition of royalty also now. 9 judges bench has come. I have not read that judgment. Royalty is not tax. That is
Yes, yes.
that is the only point I have understood.
In a recent judgment.
Huh?
Yes.
And that includes mines and minerals also.
Yes.
We have to find out that judgment also. Hey, নতুন যারা 9 judges কিমান মান পেজ নাজানো চাব লাগিব. That might have an impact here.
Okay.
Because tax and royalty is different. Now, state has a power to collect royalty. That is also one of the observations.
Yes. Sir.
Have you gone through?
The judgment.
Huh?
I've-
I have not also gone through. To be frank, this much I know that state, in spite of central legislation, state will have the power to collect royalty. And that includes mines and minerals. Now let us mines and minerals development act Assam. This rules are framed under what? Mines and Minerals Development and Regulation Act 1957.
Yes, I'm coming to that.
Because this is a perennial problem.
Regarding if lordship comes to page 248 of the Assam Minor Mineral Concession Rules 2030, there are certain relaxations are there, Lordship. Or Lordship, where royalty cannot be charged. In which case, Lordship?
Now, under what source of power these rules are framed? Why? Why? Do you have any idea? Page
Page 248, Lordship.
248, section,
Rule.
Uh,
regulation.
Assam Minor Mineral Concession Rules.
I have this.
Yes, Lordship. Lordship. Section 4, relaxation in certain cases.
Regulation 4.
Lordship, relaxation in certain cases. No royalty or permit fee shall be charged or transit permit required for 1. Extraction of ordinary clay or ordinary sand by hereditary artisans for use in manufacturing of art and pots, stroke artifacts on a cottage industry basis. 2. Mining, transportation or storage of clay or sand by hereditary artisans or a cooperative society of artisans for making pots or other images, etc. by tradition means, but not by the process of manufacture on cleans or by way of any mechanical device. 3. Leveling of any agricultural fields by a landowner within his own land. 2. No royalty shall be charged for removal of any ordinary art by a person from his own land for meeting personal land field requirements either in any agricultural field or for meeting his personal bona fide requirements. 3. The relaxation granted under these rules shall not be available for excavation of mineral in any area where use of explosive is inevitable, whether being mined or by a concession holder or not. This is not required, I suppose, Lordship. If Lordship comes to
Let us read the provisos.
Provided that the aforesaid relaxations do not afford immunity from any action which might be taken under the provisions of any existing rules or acts of the state or the central government or unauthorized removal of minor mineral from any government land by private persons without the permissions of the competent authority or the state government or any officer authorized by it in this behalf.
Government land.
Lordship, unauthorized, removal of unauthorized.
No, this is continuation.
Lordship,
Provided that the aforesaid
That
relaxation do not afford
immunity
immunity from any action
Hmm.
which might be taken under the provisions of any existing rules
or acts of the state or the
for
central government
unauthorized removal of minor mineral from any government land
or
by
private.
private person without the permission of the competent authority or the state government or any officer authorized by it in this behalf.
That is
Now,
government land.
government land,
That is
unauthorized removal of minor mineral,
That is for applicable for government land.
government land,
But in our case,
immunity will not be provided. Now,
but in
there is that subclause 2, no royalty shall be charged for removal of any ordinary art by person
for his own land, from his own land, for meeting
for
his
meeting
personal
landfill
land,
requirement either in another,
in another agricultural field or for meeting his personal bona fide requirements. This is not for his personal bona fide requirements here.
now, whether it has been settled that ordinary art is minor mineral,
Lordship,
ordinary art is minor mineral, any
Lordship.
law?
Bismillah. In the judgment I have referred, Millet. It is
None.
it is referred. Rule four, my lord, what I found, my lord, rule four, he is referring, is in the light of rule three, my lord. What rule three says, power to grant mining lease
And
or mining contract.
1 minute,
Yes,
let,
ma'am.
let rule 4 relaxation in certain cases.
In. In
This
rule,
is 4. 2. Transportation of removal of ordinary earth.
if your lordship comes to rule 5,
Okay, 4.2. No royalty shall be charged for removal of any ordinary art by a person from his own land for meeting so and so.
I have also taken the ground. Personal bona fide.
Personal, that is business.
lordship,
So it does not include his case expressly. So by implication, royalty shall be charged for removal of any ordinary art by a person, from Patalan. If Mr. Das has a plot of land A and plot of land B, if he removes art from plot A to plot B, then no royalty will be charged. Or for his personal bona fide requirement, or in another agricultural field.
then no royalty.
So by implication, if from Mr. Das's land, Mr. Hazarika removes land, then royalty will be charged. Impliedly, not directly. If we read regulation 4, this rule 4, and there is another one, I think 27.
Lordship, rule
27.
5 also. In
Hmm?
rule 5,
Rule three, lordship will proceed.
Rule
five.
3.
Yes. Enter
Rule 3. Let us
Yes, ma'am.
see. Rule 3. Which part?
rule three, a mining lease or a mining contract or permit. In this case, these,
Rule 3.
yes, ma'am.
Power to
Rule
grant.
three, power to grant mining lease.
Huh? Rule 3. Rule 3. Yes.
Power to grant mining lease or mining contract or any other concession or license or transit pass. So I'm referring this clause because of the definition made of mining lease, mining concession holder, mining concession. This contract doesn't fall within the meaning of mining contract. A mining lease or a mining contract or permit. In this case, he is referring permit or any other concession or license or transit pass or permit or license or control of the regulation of mining or other action under this rule, etc. shall be granted taken by the director in respect of minor.
Any other
This is
concession?
not.
No, my lord. Why I am referring this, my lord, lordship will see the definition of mining lease and mining contract and
What does other action include?
I am referring this clause. to
Because
show-
I am asking this question
Right.
because of the Mines and Minerals Regulation and Development Act 1957. I am asking this question. The source was there. From that source, this has been These rules are framed.
Yes.
Source is there. Now, what is this other action?
And even if you go by rule 27.
We'll
that
go by
the-
rule
yes,
27, but
27.
There
the
is-
First schedule, it doesn't include the
Before
we'll
that,
come to that.
Mileage.
We are going,
one by one.
one,
don't jump here and there,
Yes.
then I am not
That
that
is,
sharp
that is-
as you, Mr. Azorika.
Rule 4 is related to, my lord, directly related to rule 27.
Yes, we'll go to that. Now, reading rule 3, it is not clear. Other action, mining lease, mining contract, permit, any other concession, license, transit pass, permit, license, control, regulation of mining, or other action. Other action under these rules. Whether other action includes transportation or not, or removal or not.
I don't know.
if your lordship comes to rule 5. It's Rule 5, quarrying of minor minerals by government department stroke agencies stroke contractors engaged by government department or agencies.
Wearing of minor minerals by government department.
Sub-rule 2, lordship. Rule 5, sub-rule 2, lordship. The contractors engaged for the works stroke projects of the government department stroke agencies shall be granted mining permit for the required quantity as specified in the detailed project report for the execution of the works stroke projects on making an application under sub-rule 1. And in rule 3, lordship, 3.1. Then there's below 3.1. The minor minerals when be consumed shall be consumed by government agencies. The rates of royalties shall be deducted.
Grant of minor minerals by notice. No, what is 27?
Lot. Twenty-seven, sub-rule 4. Royalty shall be charged on lump sum
One
basis
minute.
on the basis of
Is a mining.
which relates to permits or extraction of ordinary.
27.
27, sub-rule 4.
Let us read to a whole.
My lord.
Because here, Mr. Das and Mr. Hazarika, they are not concerned with mining operation, mining lease, mineral concession, mining permit. It is simple removal of art and transportation of art. There is no question of mining and all exploration.
That's why I'm referring.
Art on the face of the art are to be removed from Pattaland to the project site,
Yes,
right?
Yes, lord.
Transportation from Pattaland to the project site by trucks, thellas,
Whatever.
pickup vans, whatever, right? We are concerned with this question.
my lord.
Nothing else is, it is mining is different thing.
Yes, sir.
See the definition of mining, lease,
Yes, my lord.
mining plan, mining operation,
That's why I'm.
mining
referring
permit.
the
Yeah,
right.
definition of-
That
yes.
is,
Rule
That-
5 concerned with that,
That,
that is,
that there is a distinction, it is clear from rule 27. a competent authority may grant permit for lifting of ordinary art. So here we are concerned with lifting of ordinary art from a patta land to the project site. It is not rocket science.
That is what Lordship in
Ah.
Rule 5,
From an area
Rule 5,
No.
Sub-Rule 3.
not
Already
already granted
On any mineral concession to the
to the
landlord
landowner.
or the person having consent of the landowner or on submission
So,
on an application.
The competent authority may grant permit for lifting of ordinary art from an area not already granted on any mineral concession to the landowner. Permit is to be granted to the landowner
Right.
or the person having consent of the landowner. Now here, Mr.
the consent.
Hazarika may come in, contractor, having consent of the landowner
Right.
on submission of an application. The permit for extraction of ordinary art shall be granted only up to a maximum depth of 9 feet, measured from the natural ground level of said area. The permit of extraction of ordinary art in respect of any land of which
Ownership
3 is not required, I think.
is not relevant. 4 is relevant.
4. The royalty shall be charged on lump sum basis on the basis of quantity or volume of the art for which the permit is applied, granted as per the rates prescribed in the second schedule.
First schedule.
First schedule. The payment of royalty in this case shall be made in advance for the complete financial year or part thereof.
Now the first schedule or see.
Let us see the first schedule. There it was 0.
0. And subsequently in 2021.
We'll come to that. Don't. Why you are so impatient? Schedule? First schedule.
Yes. Rates of royalty.
First schedule. First schedule.
Last in my book is page
First
58.
schedule.
Yes.
Okay, first schedule.
Last of the
Mr. Das, on that day I asked you whether
Yes, regarding that, Lordship. I have
this
to-
was correct printing or wrong printing, because nothing was mentioned
Yes, Lordship.
against ordinary art,
Lordship.
rate of royalty.
Now that the
Ordinary
amendment has come in.
Huh?
Amendment has
Will
come.
come.
in. Yes.
Then let us rule 5 also. Application for grant of permits shall be submitted in model form PIM 3. PIM 3. PIM 3. PIM 3.
In the second petition, I have annexed it form.
It is there.
Yes. Yes.
It will be there.
Yes. That is there.
PIM 3.
Lordship.
Then application shall be submitted along with the following documents: layout plan, written consent, partnership deed, particulars of the land from where he proposes to extract. Then a permit for excavation or ordinary art shall be granted on model form PIM 4. Whereas so-and-so has applied for grant of permit under so-and-so contours of ordinary minor minerals for excavation, paid royalty in advance. See the permit. Clause 5. The permit holder shall not enter and work in any forest without obtaining prior written permission of the forest department. So meaning thereby, forest
It has to be
authority does not have any jurisdiction regarding ordinary art. Now, without going into other decision, let us, if this is applicable, suppose Rule 27, they are required to provide as per PIM 3 that I have the consent of this landowner to remove, say, 100 cubic meter of ordinary art for the purpose of utilizing it for my project. Please grant me permit. They are mandatorily required. Out of the two, one applied.
Yes, Lordship.
The other, according to Mr. Hazarika, he has no information. So let us assume he did not apply. Without the permit, he had removed it. Now, what will be the consequences? For the one also who applied, he was not granted the permission.
Lordship, permission was there.
Hmm?
I have the copy. Permission was there.
Let us see.
We have to prepare a mining plan. Lordship.
Matter is getting complicated. How mining plan, mining operation? It is simple removal of earth
Yes.
from Pastaland
That
to
is clear rule 48.
transportation. Everybody is complicating the matter.
We are replying to that clause, well, rule 48, mining plan,
engineer
where
has-
mining plan is required.
Lordship, executive engineer has repeatedly asking the petitioner to submit the forest royalty if they have given. Nor if they are not required also, they are to be submitted. This is the latest, but petitioners have failed to
Well,
require.
decide on that. Question is, let us understand this particular
Lordship,
provision.
Lordship.
Neither Mr. Hazarika nor Mr. Das nor your executive engineer nor anybody or nor this court can go
Beyond.
beyond this rule. That is very simple thing.
Lordship,
Understanding of the law.
Lordship.
Neither your executive engineer or whoever, commissioner, secretary, right,
Lordship,
can go beyond what is in the rules.
Lordship, Lordship.
My simple question to you is that it appears for Mr. Hazarika to remove ordinary art with the consent of the owner of the land from Patta land, he needs a permit. Right? One applied, one did not apply. One who applied, you have complicated the case.
Not recent.
No,
Okay,
because rule 6 clearly says, sub-rule 6 of rule 27, a permit for excavation or of ordinary art shall be granted in model from PIM 4. I have read already PIM 4.
Lordship.
Where is the question of mining plan or all this? No,
That is-
absolutely not.
that is the PIM.
Your executive engineer or somebody
No,
has gone
PIM.
beyond it. See, PIM 4.
Yes.
Do you have the model from PIM 4?
Yes.
It is very simple. Very simple. Rule 27 itself is very simple, that for lifting of ordinary soil, where is the question of mining plan for removal? Right. Now, let us assume permit was not granted to any of them.
What will be consequent?
Then what will be the consequence? They have violated
Forest.
27.
Yes.
Without, though they had the consent of the landowner, but they did not have the
Permit.
permit under Rule 27. Okay. What are the consequences? Otherwise, very simple.
Yes.
If minor mineral includes ordinary art,
Yes, Lord.
as per your table of first schedule, ordinary art
Nil.
is minor mineral,
Minor.
right?
Right.
And I think that somewhere else also it was minor mineral. First, not first schedule. Schedule Y and schedule, there are two schedules,
Yes. Minor. It is
X
minor.
and Y,
There is no dispute, man.
ordinary art. Schedule Y, please come to schedule Y. Rule 3.2, right?
Yes.
Item number 15, ordinary art.
Yes.
Let us read rule 3.2. Three,
Three. Ordinary art.
rule 3. Where is rule 3?
Is 8, 5, 6.
That's schedule Y.
Yes.
Schedule Y is ordinary art 15.
Yes, ma'am.
Now, whether this is then minor mineral rules 1960. What is this? First schedule contains
First civil content.
first 86.
The lessee
Also,
civil-
rule 86,
The lessee.
pay royalty,
Pay royalty, the lessee. will-
lessee. Then 26, 6, 26, 6. What is 26, 6? 20 rule 26, sub rule 6.
Lordship.
That is brick art,
Yes, ma'am.
is it not?
Yes, royalty on account of extraction of brick. art.
Brick art. We are with ordinary art.
Ordinary art.
So it is simply 27, rule 27.
Rule 20.
So they have violated. Then what will be the consequence? If violation of the rules, then what are the penalties? Or is a penalty clause, Mr.
Yes, ma'am.
He should be punished.
Chapter 12, madam. Illegal and unauthorized mining and consequences.
এখন মানে প্রিন্টিংটো অলপ বেয়া আছে, সিরিয়ালি নাই। মানে রেগুলেশন কন্ট্রোল। Any penalty clause that if no permit is obtained, then the word is permit, right?
Yes.
Say for rule 64.
Chapter 12. Any act illegal or unauthorized mining.
Any act of illegal or unauthorized mining shall be liable to the following. A. For a first-time violation, the said mineral shall be liable to be seized. Now, mineral is already utilized.
Yes.
Liable to be seized along with the impounding of all such tools, equipment, vehicle, or any other thing used for such unauthorized operation, which may be released upon realization of the payment of price of the mineral. Applicable royalty. If royalty is paid, everything will be released. For the mineral extracted, payment of price of the mineral and the applicable royalty for the mineral extracted and In addition, a fine which shall not be less than 10,000 rupees. For second time,
For second time violation, the said minerals shall be liable to be seized along with the impounding of all such tools, equipments, vehicle, or any other things used for such unauthorized operation for a minimum period of 7 days, which may be released only upon realization of the payment of price of the mineral and the applicable royalty for the mineral extracted, and in addition, a fine which shall not be less than 15,000. Third time violation will whenever the person is found to be indulging in such offense for the third time or more, the officer concerned shall register an FIR and hand over it all such tools, equipments, vehicle, or any other things used for such unauthorized operation to the police. Any such offense shall entail a confiscation of all such tools, equipments, vehicle, or any other things used for such unauthorized operation for a period minimum 30 days or not more. B, pecuniary penalty or punishment for the offense as provided under section 21 of the Mines and Minerals Development Act 57. Now,
21
20
penalties.
penalties is there.
This act also.
Yes, ma'am.
21 of the minor mineral, that is third time violation.
Penalty.
First time forfeiture, second time forfeiture with collection of the price of the mineral and applicable royalty. Right, plus fine. This is the consequence. Otherwise, as per law, if ordinary art is considered to be for that purpose, to realize royalty and everything, he has to be put on notice. You cannot deduct.
No, we have given them the notice, Lordship. It is before your Lordship. 2 times, mainly 15 and 16.
Now the question will be, next question will be price of the minor mineral. Who will extract and to whom it will be paid?
It will be paid to the, it will be deposited in the government account.
Why? It is the landowner's property.
Lordship, ultimate royalty has to be recovered.
Royalty, it is royalty.
Okay.
You don't have any right over the price. See,
Price as per schedule, Lordship.
only upon a realization of the payment of price of the mineral. If this clause is applicable, it is not there but because it is not saying anything, permit. It is saying mining, but we are not concerned with mining. We are just taking it for an example, right? It is simple removals. Rule 27 says simple removal. Can you point out any other provision? Because not applying for a permit may not be an offense. Right? Here it is mining,
Yes, Lordship.
and mining is different as per your own rule. For removal of art from patta land to the contract site, yes, royalty is already that there is a first schedule under Rule 27. And as per your PIM 4, the applicant has paid royalty. PIM 4
Well,
in advance amounting to so and so. Right. and rupees so and so on account of mines and minerals development and rehabilitation and restoration fund, 10% of the amount of royalty. And rupees so and so on account of security, 50% of the amount of royalty, right? Now, my next question will be, when it is zero, when it is zero, the first amount will be zero. And automatically next two amounts will also be zero.
Yes, Lordship.
Now I have given you the food for thought. 27 is clear. Without going into all these decisions. You have asked for royalty. He should have applied for permits. One applied, the other did not apply. One, you have complicated the matter, I have seen. It should be simply in PIM 4. Removal of art. Right? Your contract does not require any kind of mining. Your contract agreement.
But it's written in
Contract agreement, please see.
the contract, Lordship.
Locally available ordinary soil, excluding minor rocky soil, free from roots, vegetation, filling in uniform layer, not exceeding thick so and so, cutting and cleaning light angle, trees up to so and so. Nothing mining kind of thing.
No.
Nothing mining kind of thing.
Only borrowing of art from private land or forest royalty. If it-
It is not,
Payment of
I am
royalty.
saying that not rocket science means nothing mining.
Yes.
Simply removal. It is embankment. What is embankment? Put the art there by the side of the river. That is all. That is the contract. No kind of mining. So 27. If 27 comes into picture, permit is required to be obtained. They did not obtain permit. What will be the consequence?
Material has to be cheese and.
Whether there is an offense or not, that is one thing.
Yes.
It is not mining, I have said. We have just read one particular provision,
Yes.
but that includes mining. Here it is, 27 says removal. Now your, this does not contain any consequence.
If it is mining, that consequence will come.
If it is only removal, 27, then that does not include any consequence.
Right.
Suppose they do not obtain permit. Impliedly, royalty is payable. But your rate of royalty is zero.
Here, Lordship.
Your rate of royalty here in schedule, first schedule is zero.
Lordship, there is. Yes, there is zero in 2013. This is the
The contract-
schedule
contract
schedule in
is-
2013.
The contract is of
Lordship, now
2013.
if Lordship comes to
Yes, please tell me.
the notification of 2009, Lordship, page,
That is forest produce.
yes, page 62.
That is
not
forest produce.
Rates for sand, gravel and stone, Lordship.
That is
Heading.
That is forest produce.
Lordship,
Don't jump to forest act now.
Lordship,
We are dealing with now minor and mineral,
Lordship,
minor minerals.
Lordship.
We are not dealing with forest produce.
yes, Lordship is absolutely correct, but here Lordship comes to.
Because these issues are not dealt with in any other case. That is
Right.
why I'm trying to
Right.
find out whether I'm going in a correct way or
It
not.
was pointed out that the Assam land and revolution.
Yeah.
That is absolutely not discussed.
No?
No.
New rate came when?
PIM.
If Lordship comes to in PIM 4, page 850,
PIM four.
Yes, Lordship.
Yes, I'm into PIM four.
Lordship.
PIM four.
Lordship.
1 minute.
The permit holder shall not excavate any other mineral other than ordinary clay, stroke art. Clay and art is the same, Lordship.
Other than ordinary. No,
PIM four.
Page 850.
close communication. Thing.
8.
Yes, holder.
Shall not excavate any other minerals than that of ordinary art, stroke clay. That means clay and art is to be the same, Lordship.
Clause.
8, Lordship. Page 850.
Any breach will entail suspension.
No, Lordship,
Just-
before that, the permit holder shall not excavate any other mineral than that of ordinary clay, stroke art.
Right.
Means clay or art. Clay and art is the same, Lordship.
Any other mineral than that of ordinary. art.
No. Then that of ordinary clay, stroke art.
No, That's
Clay
right.
or art,
Suppose he has done it.
Lordship.
He has violated it. What will be the consequence? Come again. Any breach
Next sentence.
in this regard would
Yes, any
entail
breach in this
immediate
regard.
suspension
Yes. Will
of the
entail-
working and followed by termination of permit.
He has
Had
not-
it been permit been there, next,
he has not
along
accepted-
with forfeiture of security amount after affording opportunity to show cause. In case any mineral is disposed of illegally, the officer in charge shall also recover the amount of penalty in accordance so and so and so and so.
Lordship. He has
So
not
what are
ob-
the consequences?
No,
he has not obtained any permit, Lordship.
Right, so he violated.
Lordship.
What will happen?
Lordship, we have,
You will recover royalty.
Lordship, we have asked them to.
You, right, you will recover royalty. But what royalty?
The art which they have extracted means the art which.
Where is the rate?
Lordship,
What is the rate?
rate is there only, Lordship.
Where?
Clay and art is to be the same, Lordship.
Where?
Lordship,
Rate, where is the rate?
yes, Lordship. Although it's not been stated in this.
This is ordinary clay or art stroke.
Yes,
Now here is a case of, clear case of art.
Art.
Art,
Then in that case, then 15 rupees per cubic meter.
where
because
is?
This first schedule, Lordship, page 858, that ordinary clay, but art is not there. But here, if we assume this one,
Legislature or your government has consciously made it. We always have to assume that everything has been incorporated in the rules consciously.
Lordship,
Now you are now say that ordinary clay 15 rupees.
yes, Lordship.
Everything is clay and ordinary clay and ordinary art. There are two rates. One is 15, the other is 0.
Lordship,
So definitely those are different things.
that I have queried with the forest department also, that is.
We will not do. Your DFO cannot explain this.
It is, cannot go beyond the statute.
He cannot explain this.
Lordship. It's.
Your DFO cannot explain this.
Lordship,
You are from irrigation,
no, what I'm sure.
water resources.
Lordship.
You are from forest.
No.
Forest,
So
is
you
not
cannot
being-
explain.
Forest is not being made a party, Lordship.
forest is not a plot.
Question is of your taking royalty.
Yes,
Where from you have got the power? If we go by that, that is different, but source is not there.
regarding this, then forest has to be there, Lordship, otherwise I am being what, from the water resource department will not
No,
be able.
you have deducted the amount and
Yes,
my
but we have
specific plea is that you are not the authority to deduct. the
Where
amount.
is the authority to deduct the amount?
My specific plea is that you are not
Lordship,
authorized to.
we have sent the notices to the petitioners, Lordship.
Notices will not do, just by sending notices, you cannot derive the source of power.
Lordship, For that, Lordship, we have already written to the DFO also for issuing of the forest permit to other parties also, because this dike is not being constructed by only these two petitioners. Other contractors were also there. We have written to the DFO for issuing of the forest permit, Lordship.
Presently, you have taken steps, that is one thing.
Lordship, this is in.
For new contracts, you have done. But the things which had already been done,
Lordship. That
that is to be treated differently.
Yes, that is there in the contract agreement also, and that agreement has also been signed by the petitioner also, Lordship.
Which one?
The contract agreement where reduction of royalty was mentioned, Lordship. That has been signed by the petitioner also. He has agreed.
There is I'm asking the question, that 2009 notification
Lordship.
is of forest produce.
Lordship.
There the rate was there. No doubt about it. But here is clearly Pattalan. You have not found him, you have not caught him using forest land.
Lordship.
Here it is, pure question is Pattalan. Pattalan, where the landowner has arrived at an agreement with the contractor.
Lordship.
And your rule 27 takes that factor into account. Now, next question is the royalty. Now, who is the authority for ordinary art? Who is the authority for ordinary art?
Our instructions was that, means not my instructions, the instructions which the department has to follow them.
Ordinary authority is principal chief conservator of forest and forest force.
We used to deduct.
Right. Now, if he has violated, forest department should have proceeded against him. One part.
Lordship.
And you say that we will collect the money meant for forest department
Yes, Lordship.
from the contractor. That is your case.
We used to collect with the money, means we used to deduct not only this, Lordship, we used to deduct income tax also. Not only this, Lordship, we used to deduct income tax also.
Income tax is okay.
Okay. These are. Income tax, sale tax, all this we used to deduct, Lordship.
That is not the dispute.
Lordship.
Dispute is regarding royalty, deduction on royalty, right?
Lordship.
Deduction on royalty.
Lordship.
There is another notification somebody was pointing out earlier. This is the only one, or
There is a notification of the finance department.
let us see that.
Yes, ma'am. There, my lord, ordinary letter is not included.
Hmm?
Page 36.
Of Pranjal,
Yes, ma'am, Nobin.
Nobin. Ah,
There is
Nobin.
page 66 in Pranjal. Payment of royalty of forest produce. It starts with,
Page
in Nobin, it is page 36. Oh,
30,
sorry, 86, last page.
86.
86, sorry. Last page.
86, last page.
The notification dated 17 June 2000 by the finance department. And it regards to.
So
payment-
forest produce,
Forest produce.
forest
Yes.
produce.
sir. And their entire case is based on this notification. And the division bench says it should be incorporated with the contract agreement. In all this has been.
Now, what is the amendment in
Amendment?
2021?
Yes, well, it is 9% rate. And it will affect the rates. Will be applicable in the fresh standard.
Fresh tender.
Yes, ma'am. Amendment of Rule 27.
That finance is forest produce. that notification 2009, that Forest Finance Department notification is 2000.
Yes, 2000.
That is in respect of forest produce.
My lord.
This your 2000 notification, which is appended to the Assam Forest Regulation, is also forest produce, right? Now then, Patalan,
2010, there is one
let
notification,
us see.
OM, by the finance department.
Forest royalty again,
2000 also, that,
2000 we have read,
Yes.
yes, that,
forest produce.
the forest, after bill should be paid after deduction of forest royalty.
No,
That is
the
the
notification
Now,
regards
what
to
the royalty is on forest produce.
Logic.
subject.
And your rule 27 of the minor mineral concession rule speaks about another royalty. See there, Mr. Das, one is forest produce, one is non-forest produce, right? Ordinary art collected from forest areas will be forest produce. Ordinary art collected from areas covered by Assam Land and Revenue Regulation will be non-forest produce. Correct? Now, forest produce invites forest royalty.
Forest royalty.
Non-forest produce cannot invite forest royalty.
Yes.
And that is why Rule 27 of the minor mineral concession rules speaks about royalty.
Logic.
Am I correct or not correct? See, I have just, all these judgments have confused me. All these judgments, number of judgments are there, you have produced. That has confused the matter more. I am trying to understand from the point of law first. And somewhere it says about ordinary art is minor mineral.
That is
Supreme Court
just-
judgment
yes,
perhaps.
Yes, yes, I have
Yes, my lord.
provided you.
That is not disputed, but it should be collected from the forest area, then taxes will be.
Forest royalty cannot be imposed on non-forest produce. This is my common sense.
But there is a division bench judgment, Lordship.
Which one?
That airport authority, which I have already submitted.
There is a clause,
Ordinary art is also being extracted from private land, that has also been.
there is a
taxed.
clause, my lord, a contract clause. There is a,
Airport authority of
no,
India.
there is a
Lordship.
clause saying that there is a rate of royalty. my lord. And he has violated, in that case, he has violated, there is a specific plot of land and he has violated that. He has extracted from other land. my lord. I remember clause 5(1) perhaps. my lord. Clause 5(1) of the contract says that there is a rate in that case. my lord. These are correct.
So on statute,
Lordship. Lordship.
that is Assam Forest Regulation 1891, Mines and Minerals Regulation and Development Act 1957, Assam Minor Mineral Concession Rules 2013, framed in exercise of the powers under Mines and Minerals Act 1957. These are the laws. These are the laws. And plus, below that, all these are notifications, office memorandums, right? Then next comes the decisions. Now, whether any of the decisions has dealt with Rule 27.
In this
I have-
decision,
I have to see, Lordship.
No,
I'm on.
in this decision, no.
That is what.
This decision.
Now we have understood the
Yes.
laws which are in force.
Your lordship is specific that rule 27, whether any of the judgment
No.
refers to rule
Dealt.
27.
And if division bench has dealt with the issue, then I'll be bound by it.
Lordship.
Whatever my perception will be, I'll be bound by it. Then I do not have to travel the
Yes.
long distance,
Yes, sir.
right?
Starting from Muslim Ali, Trinoyan, all this. Section, rule 27 is not discussed.
It was in the book when few decisions are rendered. Whether it has been dealt with, right?
I
If
have to
not
go-
dealt with,
Then
then
I have to go.
the court will decide on 27. Because I have read earlier, but
I'm okay.
this one is going there, this one is going there. It is very difficult.
Yes, lordship.
Now we have
Come to a
threadbarely discussed the
rule
provisions of.
27. Yes,
Now
sir.
we are clear about it.
Yes.
I have also read down. Because minor minerals removed and transported, yes, royalty can be imposed. Then they should be proceeded with
Malu.
as per law. If they are found that they did not pay any royalty. Right. Then in the basis of the observations, whatever we made, you have to follow them. Now it will be not forest royalty. We'll clarify. It will be royalty only. If that is royalty, then it will be governed by. Then if it turns out to be zero, then zero. Or if you can say that no, don't, without solid
Yes, lordship. Thanks.
legislative backing, don't say that it is forest royalty. Now, don't come on the next day and again repeat that forest royalty, unless very good reasons
Are there.
can be shown by you.
Lordship.
At least we have found that forest royalty, forest produce will invite forest royalty, and minor minerals will invite royalty. At least
Some condition.
prima facie,
Yes.
unless you come up with something really with some authority. Mere submitting here and there will not do. Now, Monday কি আছে? Monday কিবা আছে? I think it ought to have been better if I had sat in single bench. Monday নহব, Monday নহয়, এটা কাম কৰো। You also jot down in a piece of paper your bullet points. 1.5 page or within 2 page.
Yes.
Only the bullet points. Next week division bench আছে, আকৌ বেলেগ division bench আছে। ব্ৰেক হৈ থাকি পেলাই মিলাব নোৱাৰিব পাৰো। Let us have it on 12.
Monday. Can it be on 13?
Because there in the next week there are division benches this way, one division bench, then another division bench like that. I'm not sure when it is. Then tentative time will sit at 3.
13, Tuesday. If possible on your part, on the part of your lordship.
Better to have 12, then I will read all the judgments. It will be easier for me. If required, we'll roll over. Okay? Because you have given us so many judgments. কোনখিনি এইটো কি পেমেন্ট ডিডাকশন প্রাঞ্জল গৌতম দাস এখানে থাকক বাৰু You have gone for impact assessment, environment impact assessment
Yes.
for ordinary art. If it turns out that yes, you are liable to recover royalty, right, as per 27.
Yes.
Then thereafter, royalty rate is 0. Then it will be a case of operation successful
Yes, and right.
is in this day. It could be a possibility. Third, Mr. We are passing W Pesicata ওপৰত দিব W এইটো P Hazarika Learned Council for petitions in both the writ petitions and Mr. R.N. Das Learned Standing Council Water Resources Department for all the respondents. Raise the case again on 12/8/2000. Interim or pass shall continue till the next date of listing. I don't know whether I'll be sitting in division bench or single bench on 12, because in the next week I'll be sitting in division bench. If I sit in the single bench, then there is no issue. And if I sit in a division bench, then probably at 3. এইখিনি ভালকে থৈ দিব আৰু আছে নেকি বা মোশন এইখন কাগজখন দিব এইটো হেৰি কৰিব
If it can be on 13th.
If division bench, then only this item will be there.
Yes.
If single bench, then we'll put it on 12th, we'll put it on 13. Okay. If division bench is there, only this item will be there. No other items are fixed.
Time being method item number 1.
Yes.
In pursuance of the advertisement dated 4/8/2023, I applied for the post of peon.
14/8.
14/8.
Yes.
In the
Two post peon.
peon. In the written test, I am qualified. Written test annexer 3, page 18, Lordship. And
Page 18. Your STH.
STH, Lordship. And I obtained marks 39, Lordship. That was the highest mark. But in Viva, after advertisement, Viva total marks was 20.
Viva, who is Viva marks?
The Lordship, page annexer 1, page, annexer 1, page 14, Lordship. Page 14.
40.
14.
14. Viva.
Viva. Common written test of 50 marks and stage 2 interview Viva, Viva 20 marks. But In Viva, Lordship kindly see annexure 4, page 21.
Page 21.
Page 21.
Yes. Compile marks obtained by. Hmm.
In Viva, total marks was 60. And I got 38, Lordship.
Hmm.
This was very much unfortunate. Lordship. As per advertisement. It should
You
be
got 38 and
38.
what is your case? Sean Signal. You got 38.
38.
Huh.
Lordship, in as per advertisement, Viva mark was 20. But the total in
Oh,
Lordship. That is my case.
thereafter result has been declared.
Result has been declared.
Yes.
On the face of it, madam, he secures 39 in the written and deducted 1 mark at the Viva stage.
Hmm? He secured written 38 out of 50.
Out of 50.
39, madam.
39.
Huh?
39, madam, page 19,
Page
19.
19. No. One post was reserved for STH.
Lordship.
And who was selected? Vishwan Singh. He got 12
He got 12. Lordship.
and he has improved brilliantly, I think, and got 56. But whereas I think it should be averaged,
Yes.
the marks by the 3 interviewer should have been averaged even by the 56 divided by 3 will be 118. 18, say 18. And this man will be about 13. So 39 plus 13 will be 52. And 12 plus 18 will be 30.
Yes.
Still by that standard also. Take your instruction whether this has been they have been appointed. But they're appointed.
That's good.
Huh?
Lordship may be appointed.
Do you have any instruction?
That I wouldn't know, but.
As per instruction, appointed. Lordship.
Appointed. Had not been appointed, then
May not be.
appointed, then subject to the outcome then. We don't know.
Subject to that.
Heard. Mr.
P. Boregi.
P. Boiragi, Learned Counsel for the petitioner, and MSS Sharma Learned Standing Counsel, Guwahati High Court. For the respondent number 1, 3,
and 4.
4. First of. The petitioner has instituted the instant writ petition to challenge the appointment, selection and appointment of the respondent number 5. Portion 2. A selection process initiated by an advertisement dated 14/8/2023. Post of. Para. by an advertisement dated 14/8/2023, comma, the respondent number, office of the respondent number 3. Invited applications for filling up 2 vacancies within bracket SC1 plus STH1. In the post of office peon. Post of, as per the advertisement, comma, the selection process was to comprise of a common written test for 50 marks and interview stroke viva voce for 20 marks. Full stop. In response to the advertisement, comma, the petitioner submitted his candidature and finding his application complete in all respects, comma, he was issued an admit card to appear in a written test on 25/2/2024. Full stop. After completion of the written test, comma, the respondent number 3, office of the respondent number 3, published the results of the written test and published the list of qualified candidates to appear in the viva voce stroke interview. Full stop. In the list of qualified candidates for the post reserved for STH category, comma, the name of the petitioner figured at serial number 1 as he obtained the highest marks of 39 among the qualified candidates. Full stop. The name of the respondent number 5 also figured in the said list of qualified candidates as serial number 17 with 12 marks. Full stop. After the interview process was over, after the interviews, comma, held on 30/6/2024, comma, were over, comma, the respondent number 3 published a list of compiled marks obtained by the candidates in the viva voce stroke interview held on 30/6/2024. Full stop. In the said list of compiled marks, comma, the petitioner was shown to have obtained total marks of 38 and the respondent number 5 was shown to have obtained 56 marks. Full stop. Pursuant thereto, comma, the respondent number 3 published the select list of candidates for the post, for both the posts of SC category and STH category on 1/7/2024, showing the respondent number 5 as the one selected for the post of office peon under STH category. Full stop. It is a contention of the para. It is that Mr. So-and-so, learned counsel for the petitioner, has contended that as per the advertisement, comma, The marks in the viva voce stroke interview should have been made limited to 20 marks. But in the case in hand, but in the present case, comma, the respondent authorities had compiled the total marks by adding the marks given by each of the 3 members of the interview board. Full stop. He has, Mr. So-and-so has contended that the marks obtained in the written test and the average of the marks given by the 3 members of the interview board should have been the basis for selection. That is your case?
Lordship.
MS Sharma, Leonard, Standing Counsel GH, has submitted that instructions should require time to obtain instructions. First of MS Sharma has further pointed out that you are sure he has joined? Joined.
Actually, I am not sure.
That I need instructions. For the first time it's come up.
We're not any statement made. 1-7. We are on 20-30. 30 আজি 30 নহয় জানো?
Lordship, I'm sure he joined. Lordship.
Yeah, joined. Yeah, I'll put it in MS Sharma's mouth.
In the event
MS
he has joined. but
Joined. Yes, said fairly. Well, the respondent number 7 has already joined in the post of office peon. The matter would require further consideration. Full stop. Let notice be issued. Full stop. The notice is made returnable on 28 August 2024. As MS Sharma has appeared and accepted notice on behalf of the so-and-so. Formal notice na lage, extra copies, requisite numbers within 2 working days. The petitioner shall serve a copy of the writ petition along with annexure to the senior government advocate, Assam, for the respondent number 2 within 2 working days from today. First of the petitioner shall take steps for service of notice upon the respondent number 5 by registered post with AD within 3 working days. Post of as paid for, you sub dusty also.
Lordship.
Dusty, in addition, as paid for. Petition is permitted to take steps for service of notice upon the respondent number 5 by way of dusty, which is to be routed through the registry of the court and compliance affidavit to that effect on or before the returnable date.
Extra copy.
It is in view of the projections made, it is observed that the selection and appointment of the respondent number 5 in view of projection made, the selection and appointment of the respondent number 5 is made subject to further orders of this court.
Highly blessed.
Item number 4.
May I lordship, please? This is in pertaining to the appointment of chief administrative officer, my lord.
Affidavit is filed.
Yes.
Affidavit file completed. We also file our reply. Let the matter be taken up for final disposal, my lord. Otherwise, the post is
Someday
also lying
else.
vacant.
Someday else.
Yes.
The
No problem.
issue is with regard to, my lord, there is an interim order by which this honorable court has been pleased to or not to declare the result. Go ahead with your selection. It's a post of status there in the court of Tinsukia, my lord.
Somebody is deciding as in charge perhaps.
Absolutely
No,
correct.
Yes, there has to be one. Any convenient date.
that
12
is the
is
difficulty.
possible. Yeah, that is the difficulty. I
Sitting in
also-
division means
division,
fixing a convenient date is difficult.
That is difficult.
At least I know for sure next week I'll be there. DB,
On
Yes.
12th,
I don't know the period thereafter.
on 12, let us take a chance, Lordship, on 12.
12 that will take, okay, list the matter on 12.
Let us
Yes,
take a
Decca,
chance.
Mr. B. Dottal and senior counsel assisted by, and Mr. B. Dottal and senior counsel in the virtual mode, comma, assisted by Mr. J. Das, learned counsel for the petitioner, and Mr. H. K. Das, learned standing counsel for the respondent number, ZH for the respondent 2 and 5, full stop. As sought for by the learned counsel for the parties, list the case on 12.
Interim order, maybe.
Interim order.
Well,
Lordship. Grateful, Lordship.
Like a mile.